Part 3 of this module is dedicated to the matter of transfer of employees' contracts in outsourcing operations. Outsourcing is a tricky activity in relation to the transfer of employees. It must be carefully organized, legally speaking, because the economic consequences may be critical. According to French labor law, employees assigned to the service which is transferred from a company to another are reinstated. That means that the employment contracts in force the day the activity is transferred are maintained. Provider is obliged to keep the employees. Such regulations have an obvious purpose, which is to protect employment. The French Labour Code ensures the stability of employment if a change arises in the legal situation of the employer. The principle of transfer of employment agreements derives from mergers and acquisitions operations, but it also applies to outsourcing operations. French Labour Code guarantees the continuance of employment contracts if any change arises in the legal situation of the employer, in particular by reason of succession, sale, merger, transformation of business assets or incorporation. All employment contracts in force on the date of that change shall continue to exist between the new employer and the employees of the undertaking. The criteria for application of this rule are existence of a valid employment contract and the transfer from one autonomous economic entity which retains its identity and whose activity is continued and transferred. When you have a closer look to this second criteria, you will see that many outsourcing activities are concerned. For instance, if you transfer the administration of your payroll to a third company, then what will happen to the employment agreements and to the employment of the person at the date who are in charge of administrating the payroll of the other employees? In certain circumstances, the service provider will have to transfer the employees within his firm. The complex criteria is the notion of autonomous economic entity. One of the latest case law is concerning the exploitation of the computer applications, which were financial computer applications of a firm, which has been transferred to a service provider. The transfer to a service provider of the exploitation of such computer application has been ruled as an autonomous economic entity if the service transferred has specific resources, namely specially dedicated staff, and a management autonomy. A strong criteria is an individualized budget. Another criteria is that all the means required to continue the IT management activity has been transferred to the computer services firm, which was the case here. In this ruling, the court decided that all employment contracts were transferred to the service provider. Employers and services provider should have a specific focus on their agreements so as to govern and to implement specific provisions to deal with the transfer of the employment agreements. You have to manage the consequences of a possible application of this principle. You may also integrate a clause taking into account the cost of such an application, in case the agreement is terminated before the cost of the transfer of employees is amortized. Part 4 of this course dedicated to IT and labor law is teleworking. First of all, you have to be careful. Teleworking does not always mean working at home. Definition of teleworking is an employee in the company who regularly performs work outside the premises of the firm using information technologies, either from the moment of his recruitment or subsequently. First principle to keep in mind is that teleworking cannot be implemented without the consent of the employee. Also, of course, the employee has not a right to telework. It's part of the right of the employer to manage the way people are working. Second important principle is that teleworkers have the same rights and the same advantages granted by laws and collective bargaining agreements as those applicable to employees with same situation in the company. For instance, staff representative, working hours, training, accidents, regulations, sick leave, etc. The teleworker has the same rights that the worker who is performing his work within the premises. Teleworking incurs specific obligations and specific procedures that have to be put in place by the CIO. First aspect is data protection. Employer must take appropriate measures to protect data used and processed by teleworkers for professional purposes. The company must secure and ensure confidentiality of data processing. The teleworker must be informed of any restrictions on the use of IT resources, internet included, and of the sanctions in case these rules are breached. Then, privacy of teleworkers must be ensured by the employer. The employer will determine, together with the employee, the time slots during which he can be contacted. If a monitoring device is set up, it must be relevant and proportional to the objective of monitoring the activity of the employee who is teleworking. When you are putting in place such monitoring device, the Works Council must be notified and consulted, and the teleworker must be informed. These aspects, these regulations, have been dealt with in other modules of this course. Since all details of the procedures and of what can happen while employees are teleworking, it is highly recommended to put in place teleworking policies which will define the scope of teleworking, the condition of accesses from home for professional activities to the IT resources of the company. Also, to deal with special control procedures at a distance. And finally, also deal with special liability for security issues. For instance, you must implement a teleworking policy if, by instance, teleworkers are working with their personal equipment and not with the firm equipment. Also, you will deal with maybe personal use of the company equipment that has been made available to the teleworker for professional purposes. I thank you gratefully for your attention and remind you that if you want to look into these subjects more deeply, you can go and consult our website. You will find much more information and major case law applying to the problematics we have been dealing with here. I also remind you that all of these modules are detailed in the publications of our law firm, namely Informatique, Télécom et Internet, and Informatique et Liberté, which are published by Éditions Francis Lefebvre. It depends on the choice of the employer. This is the employer to choose if the employee might use at home his personal equipment so as to perform telework. But if the employer agrees to do so, he has to be very careful on two subject matters. First of all, it has to be made sure that the equipment will meet the security and technical requirements of the company. Not doing so may lead to a breach of the security obligation and then to criminal liability of the company and of the CIO and the legal representative. Secondly, the company has to make sure that the equipment and software that will be used by the employee is not infringing copyright. The employer will be liable if the employee is using fake or illegal copies of software.